as a potential source. So, sorry, before I go there, I would like to draw the court's attention to paragraph 91 of our written submissions here. Paragraph 91. And we've laid over these cases here, assuming but not admitting that the president's powers can be exercised on the basis of prerogative power. We respectfully, including the defense of the realm, the prerogative to keep the peace and maintain the order, which we refer to the authorities in relation to each of them, Your Honor. But this is the important part. We say that it cannot be exercised to alter the law and to dispense with the application of the law. Your Honor, in the case Regina Miller against the Queen, I draw Your Honor's attention to paragraph 25 of the judgment. 84, 86.
Which paragraph you referring to in your submissions that cites that case?
Your Honor, paragraph 91. Paragraph 91, Your Honor. It says, after referring to the two additional prerogatives that we're referring to, he said that it cannot be exercised to alter the statute, and the footnote 36, Queen against Miller against the Secretary of State, and to dispense with the application of the law, Port of Portland and A against Hayden. And in the case of Miller against the Secretary of State, Your Honor, as referring the court to paragraphs 25, where the House of Lords specifically stated that is an important aspect of fundamental principle of parliamentary sovereignty, that the primary legislation is not displaced through the Crown, through the exercise of prerogative powers.
Okay.
Hello?
Yes, Mr. Ford, we're hearing you.
Yes, Your Honor. So I was looking at paragraph 25, Your Honor, that the court only has those prerogative powers recognized by common law, and they're limited. It can't be used to alter the law of the land. This specifically at paragraph 25, page 75, B, letter B. So, Your Honor, the law exists as expressed in the Constitution, and it cannot be used to displace Article 211 of the Constitution. Neither the other cases cited. Am I there? Hello?
Yes, I'm hearing you, Mr. Ford.
Oh, yes, sir. It seemed frozen for a moment.
Okay.
So, Your Honor, okay. So, Your Honor, at paragraph, at 91 also, I refer to the case of Port of Portland, where the court says at paragraphs 13 of this judgment, Port of Portland, that in the absence of any express power for executive dispensation of the law, it does not exist at common law, and is a general constitutional principle that the rule of law and such a power is absent from the Constitution. So you can't use the prerogative powers to alter nor dispense with the application of the law. And that is also set out in the case of A against.
Well, Mr. Ford, you have many cases that are saying the same thing. Both sides have given me a voluminous set of cases that all say the same thing. I think Mr. Ford is frozen again.
Recording stopped.
Mr. Peters, you might have to take over.
Let me get in touch with Mr.
He's
Ford.
back again.
Hello?
He's back again.
Recording in progress.
Your Honor, I don't know what's happening.
Maybe take off your video, Mr. Ford. and that might help your bandwidth.
Okay.
Very well.
Thank you. So I was just referring to those cases quickly on to make that point, which I believe dovetails into our analysis as to the source of the president's power. Your Honor, at paragraphs 33, 34 of our written submissions, 34.
Yes.
Your Honor, paragraph.
Or well, let me ask you some questions, Mr. Ford. I think you've made your point. Mr. Ford, are you hearing us? Mr. Ford is gone again.
Recording stopped.
Mr. Ford?
Recording in progress.
Mr.
Your Honor,
Ford is
another device, Your Honor.
very well. Yes, I'm assuming you're about to wrap up.
Well, no, Your Honor, I'll wrap up in a couple of minutes.
Okay.
Your Honor, the two other points I wish to make very quickly, Your Honor, has to do with the application of the doctrine of necessity, Your Honor. Your Honor, the doctrine of necessity as laid down in the case of Mitchell, which requires the establishment and proof to the court of circumstances of an emergency, have not been made out on the affidavit, Your Honor. Your Honor, I believe that that is the only ground which would validate the actions of the president, because the doctrine of necessity would not provide a source of authority for whatever he has done. Your Honor, it is important to note a number of things which we would have set out in our submission, but I'd just like to highlight it. Whatever the president did, Your Honor, what he would have identified as the source of the problem, the institutions that were not in place at the time would have been the Office of the Leader of the Opposition and the Police Service Commission. The courts would have seen, Your Honor, the Honor would have seen from our submissions, we would have identified and listed a number of situations referring to the courts and what the courts would have done and what the heads of state would have done in summary circumstances for the court could just to look quickly. And you would see, Your Honor, that in every instance, there would have been an emergency, either declared or acknowledged by the head of state, because the circumstances was obvious, that would have been presented to the court as part of the evidence. But whatever the head of state would have done, Your Honor, would have been targeted directly to that event. In this situation here, Your Honor, what we have is an act, an unconstitutional act by the head of state, not directed to either the Constitution, the establishment of the Leader of the Opposition office, or the Police Service Commission, but to bypass it completely and to get to deal with another aspect of a provision in the Constitution.
When you
Your
say
Honor,
bypass, what you mean?
Your Honor, based on the test, my understanding of the test, of the doctrine of necessity, it must be proportionate to the issue and you must utilize the power to deal with what is the problem. For example, Your Honor, in the case of Mitchell, or in the case of Republic of Fiji that we cited, or even the Ibrahim's case, the court recognized that the state authority was responding to what was not working at the time. They needed either to have, in Mitchell's case, we established it, there was no legislature, none could function. The Governor General issued a proclamation. Being the executive, he assumed legislative power. In relation to Republic of Fiji and the Prashad case, that matter, the head of state could not have engaged in consultation with cabinet in order to constitute a state of emergency. He dealt with a state of emergency in those situations. In relation to the Ibrahim matter, the Turkish people, I believe, had withdrawn from the government, and the legislation needed to be put in place. They did exactly that. Your Honor, in this situation, the president purported to deal with another constitutional issue. He did not deal with seeking in any way possible to have a leader of the opposition done in a manner.
No, just a minute. You were saying the president didn't seek to have a leader of the opposition?
I'm saying, Your Honor, the issue that faced the president was the absence of the leader of the opposition and the absence of a duly constituted service commission.
So what was to be done in those circumstances?
Your Honor, in our respectful submission, the president ought to have awaited the establishment of them. But I'm speaking of.
Okay, so but if you don't know when it would have been established, then what?
Your Honor, if you don't know when it would have been established, then what? The president would have had to establish, Your Honor, on the affidavits that there existed an emergency which requires the appointment. And I'm saying, Your Honor, that on the affidavit evidence before the court, there's nothing that provided any evidence or the evidential basis to establish that there was an emergency if the police commissioner was not appointed to act in the circumstances. And that is
yes, but I'm trying to understand. So you're saying that nobody should have been appointed? That's what I'm trying.
No, Your Honor. No, Your Honor. Your Honor, and this takes me to the second aspect of it. Your Honor, one of the reasons why the doctrine of necessity exists is that there must be no other option available. On the affidavit evidence, Your Honor, we have presented the court with a number of options which would have been available to the president.
Or just let's go to those then. Let's go to those. So the affidavit in support discloses other options.
Yes, Your Honor.
Okay, we're
this one.
Paragraph.
Looking at the affidavit, Your Honor.
Yes, you said you have said there are other options.
Yes, Your Honor. That's 1 minute. You want any affidavit in support be?
Or let me just ask this question before you look for that. So you're saying that nobody should have been appointed in the circumstances?
Yes, sir.
Nobody could or should have been appointed?
In these circumstances.
And in circumstances where there was uncertainty as to when the required institutions would have been appointed?
Yes, sir. Your Honor, on the affidavit in support of the application, we pointed out that for the preceding year or more, since the retirement of Commissioner of Police Leslie James, the Guyana Police Force was without either a person appointed an acting Commissioner of Police or formally appointed as the Office of the Commissioner of Police.
But there was somebody in the position. So to say
Yes,
that there
Your
was
Honor.
no, it wasn't a case of there was nobody.
Yes, Your Honor. And that is the point that I'm making, Your Honor. And in our affidavit in reply, we attached the letter, which indicated that Mr. Nigel Hoppy was appointed to perform the functions of Commissioner of Police. That is not what would have happened here, Your Honor. This was a specific appointment. This was a specific appointment by the president in the face of the Constitution to appoint someone to be the acting Commissioner of Police. At paragraph 45 of our the affidavit, we pointed out that Mr. Hoppy performed the functions for over a year and a half in our affidavit, sorry, 43, paragraph 43 of the affidavit in support of the fixed data application. In our affidavit, in the reply, we pointed out that, and we attached the document showing that Mr. Hoppy was appointed to perform the functions. The president had that as an option, Your Honor. He had that as an option. And the doctrine of necessity specifically requires that there must be no other option available. So,
you're saying that he should have used the language perform the functions?
Yes, Your Honor, it makes a fundamental difference because it would not have collided with Article 211 of the Constitution, where there's a need for meaningful consultation between
but Mr. Ford, with due respect, you can't, how can you go to 211 on meaningful consultation when there was nobody in the positions to be consulted with?
Your Honor, you've actually made my point, Your Honor, because under those circumstances, you cannot comply with it. And that is why, even in the letter in which Mr. Hoppy was appointed, he was appointed not as the acting Commissioner of Police at a time when there was a leader of the opposition and there was a duly constituted service commission. He was appointed to perform the functions of the Commissioner of Police. So there would have been no collision with Article 211 of the Constitution, whether they're there or not. So that was an option that was available. They could have appointed whoever they wish to have appointed. Your Honor, the other options were in relation to Mr. Mr. Hoppy. He was proceeding on pre-retirement leave. They could have decided among themselves at the level of the executive authority that they wanted Mr. Hoppy to stay on. That was an option.
Well, that is presupposing that Mr. Hoppy, just a minute, that's presupposing that Mr. Hoppy wanted to stay also.
Your Honor,
we can't go, yes, so I don't know that you could go down that road.
Again, Your Honor, it is when you look at the decision of Justice Haynes and Mitchell, it is the requirement of the executive to provide the court with the evidence to show that they had no other option. There's nothing on the affidavit saying that we approached Mr. Hoppy. Mr. Hoppy said, I have to leave now. There's nothing to show on the affidavit, Your Honor. Why?
Well, Mr. Ford, I'm not buying that one, but anyway.
you.